Hello and welcome to Amigos IAS. I am Adnan. Delhi Chief Minister Arvind Kejriwal has been arrested by Enforcement Directorate in the Delhi excise policy case. Now, this has thrown up some interesting challenges. The first thing is whether Arvind Kejriwal from the jail can run the administration of the Union Territory of Delhi. Second point, will he be disqualified or not? So let's try to understand this particular topic on the dimensions of law as well as the constitution. So let's jump into this. And also one important point here, already I have done a detailed video on the topic of Enforcement Directorate. So please do find the link of the YouTube video in the description as well as in the comment section. The entire details regarding what are the powers of Enforcement Directorate, what are their functions, in what cases they can arrest or not, have been explicitly discussed in a particular video that will be shared in the comment section as well as description, guys. So please do watch it. Now, when we go to this topic, the question here is Delhi is a union territory and we have Aam Aadmi Party government there and central government is BJP government. So politically also this case is going on for some time, and already we have seen the Deputy Chief Minister Manish Sisodia, as well as the Health Minister Satyendra Jain. They already are in jail in this case. So let's try to understand what actually happens. Do the chief ministers or the prime ministers enjoy any immunity in this kind of arrests? So first things first, it is only the president and the governor of the states and union territories who enjoy the immunity or the protection here. From civil and criminal proceedings. So we have to understand two aspects here, civil as well as criminal proceedings. So we have an article 361 in the constitution, which clause 1 of this talks about the presidents and the governors enjoy immunity. No action can be taken against them for what they do being in the offices. That means the official acts what they perform, we cannot take any action against them. They do have the immunity for that. That means they are not answerable to any court for what they do in their official capacity. Now, clause 2 of article 361 says, you cannot file any criminal case. No criminal proceedings can be instituted against the president or the governor for acts done in their office. And then clause 3, I'll come back to this. Clause 4 says that no civil proceedings shall be instituted against the president or the governor except by giving 2 months of notice. That means minimum 2 months of notice period should be given first, and then you can proceed with the civil cases. But here we have to understand clause 3. It says there is no process of arrest. That means there is no process of arrest of president or governor either in civil cases or criminal cases. That means you cannot arrest them when they are still in the office. So understand the key term here, when they are in the office. No civil or criminal cases arrest will be happening. No criminal case can be booked against the president or the governor. Civil cases can be booked, but we have to give 2 months of advance notice for them. So these are given specially for whom? President and the governor, but not for the ministers, guys. Now we may question one aspect here. Then ministers also enjoy privileges. Article 105, 194 are there, right? Now here there is a small distinction here. The first point is, when I say the ministers do not enjoy immunity, first things first, let me just write it clearly here. So if I say article 105 and 194 talk about privileges. Now these privileges are applicable only in civil cases. That means 40 days before session, 40 days after session, you cannot arrest the MPs or the MLAs or the MLCs, whatever, guys. That is in civil cases. In criminal cases, yes, you can arrest. That means in criminal cases, there is no privilege enjoyed by the MPs and the MLAs. Ministers also are either MPs or MLAs because the executive is a part of legislature. They do not enjoy any special privileges in criminal cases here. Civil cases, 40 days before session, 40 days after session, no arrest can be done. So here, Kejriwal does not enjoy any such kind of immunity. Criminal cases are there, guys. Fine. And now next aspect. Can the chief minister govern in this particular case? Theoretically plausible. Governing from detention has its own logistical challenges, but there is nothing in the constitution or the law which bars any chief minister or the prime minister from not performing official responsibility while under arrest. Now here very important point, Kejriwal is not disqualified, he is just accused in this case. Disqualification occurs only when he is convicted. Very important to note this. Okay, so the RP Act outlines disqualification provisions for some specific offences which also bring conviction. Okay, and if you get convicted, you may not hold the office. There exists no specific legal provision, there is no bar, okay, that there should be automatic resignation of a state's chief minister upon arrest. That means simply saying, if you got arrested as a chief minister or a prime minister, you cannot be automatically disqualified here, guys. There is no such, or resigned also. No need to resign automatically. I'll just explain this in clear terms here, guys. So as we understand, we have these articles 102, okay, for the parliament and 191 for the state, which talk about the disqualification provisions. So let's say article 102, 191, what they say here, let's say clause 1 is there. It talks about if any person holds office of profit under the government, except those which are specifically allowed as per the parliament. If anybody holds office of profit, then they can be disqualified if they are of unsound mind. Okay, let me write it clearly, unsound mind. Or next one, undischarged insolvent. Unsound mind means, of course, a competent court has to declare them they are unsound, not anyone else. Undischarged insolvent, okay, a person who is in severe debts. And then a person who is no longer citizen of India or voluntarily acquired citizenship of any other country. Okay, and E says, or 1, 2, 3, 4, 5 clauses say, okay, it talks about a person is disqualified as per any law, passed by the parliament. So these are the grounds mentioned in 102 and 191. So already we know that parliament has passed a law, right? What is that? Representation of the People Act 1951. Now in this RP Act, guys, we have offences where a person shall be disqualified. Now what are those offences? 8 clause 1 has a huge list of offences which includes IPC sections like 153, okay, 295, promoting enmity, defiling somebody's religious places. It has detailed provisions regarding Narcotic Drugs Act is there. We also have Prevention of Sati Act is there. Okay, all those 8 clause 1, all the offences as per 8 clause 1 are there. Then 8 clause 2 lists about the offences regarding adulteration of food, hoarding of the materials, etc. Okay, that is also a ground where a person can be disqualified. 8 clause 3 talks about any other offences not covered in 8 clause 1 and not covered in 8 clause 2. 8 clause 3 deals with those offences. Okay, and if you are having at least a sentence of 2 years, if you are convicted as per 8 clause 3, you shall be disqualified from the date of conviction. Please make a important distinction here, students. The offences under 8 clause 1, okay, and 8 clause 2, in these two cases, 2 years is not required, guys. Anything, let's say 8 clause 1, just now I told, IPC sections are there, Sati Act is there, Prevention of Corruption Act is there. Okay, in these cases, if you are convicted, it's enough. You will be disqualified. In 8 clause 2 also, adulteration of foods, hoarding of the, let's say, food grains, etc. These are mentioned in 8 clause 2. Please make sure offences of 8 clause 1, offences of 8 clause 2 do not require 2 years of sentence to be given. Any other offences apart from the ones mentioned in 8 clause 1, 8 clause 2, they are mentioned in 8 clause 3, not specifically, but 8 clause 3 deals with any other offences. If you get at least 2 years sentence, then 8 clause 3 says that you are disqualified from the date of conviction. And of course, in all these cases, 6 years you have to add, further 6 years you cannot contest the elections. Now 8 capital A of RP Act is again important here. It talks about corrupt practices, guys, which you do as a part of, your campaigning, etc., bribery, etc. you do, right? So those are called corrupt practices. Now 8 capital A says, what are the corrupt practices? Those corrupt practices are mentioned in 123 section of RP Act 51. So I hope it is clear, guys. 8 clause 1 talks about certain offences. 8 clause 2 talks about other offence. 8 clause 3, any offence not covered in 8 clause 1, 8 clause 2. 8 capital A says if anybody does corrupt practices, they can be disqualified. What are corrupt practices? They are mentioned in 123 section of the RP Act 51. I hope it is clear, guys. In these cases, of course, Kejriwal is just accused. He is not convicted, so he will not be disqualified. He is not going to be disqualified, guys. That's the main point here. So he is still accused. So whether he can run the administration or not, just hold on with that. So I hope you got this picture clear, guys. Now let's see what the rules are saying. The jail manual states that you can meet your family, friends or associates only twice a week. If we see the jail manual rules, guys, the prison manual, rule number 1, 3, 4, 9, these rules talk about what? These rules talk about that within the prison, when you're under trials, you can meet your friends, family, associates for only twice a week. But you cannot have access to documents, files, you cannot have access to telephone facilities. Recently, if you remember, CCTV recordings of Delhi's minister who is in jail, Satyinder Jain, these recordings have come out. In these recordings, we have seen that he is getting nice treatment inside the jail, he is having some access to phones, etc., which created a lot of outrage. So by that, we can understand that the jail manual, the prison manual does not allow anyone to sign the files, access all the facilities like telephones, etc. Okay, so please make sure. That means still he can run the government, but not able to sign the files and all that. But how long will he run? Next one, the Lieutenant Governor has the power to convert any building into a prison. And if Kejriwal can convince the Lieutenant Governor, of course not possible, guys, he can ask him to put Kejriwal under house arrest. It will help him to be a part of the Delhi government's day-to-day functioning. That means you can convert the detention of the Kejriwal into the house arrest. That means Lieutenant Governor can convert any building into a prison. He can just declare that so and so building is a prison, and then Kejriwal can run the government from that. But as we all know, the relations between Delhi government and central government are not on good terms because they are from different political parties. So already there is a friction between Lieutenant Governor and Chief Minister in Delhi all the time. So we can't expect this to happen, guys. Then last option is what? Lieutenant Governor can ask presidential intervention, because generally if any government servant, public servant is arrested under corruption case, they are asked to resign usually. And they are not as a part of the government, they won't work for some time. Similarly, what if a chief minister is arrested? That is a public servant. So here, running the administration from prison is very difficult. So it can be told or inferred by the Lieutenant Governor, because Lieutenant Governor can recommend for the President's rule as per Article 239AB. 239AA, 239AB are special articles for Delhi, guys. So Lieutenant Governor can recommend the President to invoke the President's rule by saying that there is a failure of constitutional machinery because the CM is in jail and it is difficult to run administration from the jail. It becomes very difficult to run day-to-day functions, having cabinet meetings and all that is not possible. Okay, as a result, he may say that it is a failure of constitutional machinery and ask for invoking the President's rule as per, okay, this article 356 is there. Okay, now, if it is done, then what happens? Until then, until the assembly expires, guys, they will be under the President's rule. So Feb 2025 is the date on which the current assembly's tenure is going to expire, guys. So these are the options here. Now the question is, any past precedents of any chief minister running the administration like this? No. As we understand, in the past, guys, we had instances where Jayalalitha, or in 1997-1998, Lalu Yadav, when he was arrested, okay, he made his wife Rabri Devi as the chief minister. Then if we see 2014 Jayalalitha, she was the first sitting chief minister to be convicted in India. First sitting chief minister to be convicted. And then she also had resigned from her post. And now in recently, we have seen Hemant Soren, okay, in Jharkhand. He has resigned before, okay, he is arrested. What happens here? Hemant Soren, he has given his chief minister post, he resigned, and Champai Soren was chosen as his successor. That is the current things, guys. So Kejriwal is the first sitting chief minister to be arrested. Jayalalitha is the first sitting chief minister to be convicted. Okay, so now past presidents say that when they are resigning and giving the post to the other person, because smooth administration happens, we have to wait and watch what Aam Aadmi Party will do. On the date of arrest, Atishi Marlena, all the MLAs have told that Kejriwal will run the government from the jail, but it becomes very difficult, guys. So as per the law, there is no bar for ruling, but logistically it becomes very difficult. Signing of the files, cabinet meetings, cell phones, telephone calls not permitted, guys. So as a result, let us wait and watch what the government of Delhi is going to take the decision. But I hope you understood what are the rules and what are the possibilities. So if you have any questions, please ask in the comment section, guys. I'll be happy to address your questions. And already, as I told you, I'll share the video of Enforcement Directorate in the comments as well as description. So please do watch it. Keep watching Amigos IAS. Thank you.